Afternoon, everyone. It's 5 o'clock, so we'll make a slow start. Welcome. Welcome to our June webinar entitled Compliance Chaos to Compliance Confidence. It's my pleasure to welcome back Jennifer Paddock from Jennifer Paddock and Associates. Jennifer probably doesn't need introduction, but just for those that might not have heard excellent webinars before, Jennifer's a specialist in community scheme law. She's dual qualified as both a South African attorney and an Australian solicitor. And with nearly 20 years of experience in the field, Jennifer's the founder of Jennifer Paddock and Associates, which presents the Paddock's online training courses and provides legal advisory services to the community scheme industry. Thanks very much for your time, Jennifer, and joining us tonight. We're excited to have you present. I think it's a really interesting topic. It's a really important one. And, it's one that causes a lot of anxiety and concern for our trustee and director clients. What do they need to cover? What is there to think about? How do they get governance and compliance right? So such an important sort of, opportunity just to recap if you are an experienced trustee or director, or to have some guidance on this important topic. And, it might sound fairly intimidating or extensive to those that might be new to these roles, but these slides and recording will be circulated to all those that registered for tonight. So there will be notes to go back to. Our contact details will be provided at the end. We're more than willing to provide support or feedback. We have a training website chatbot called Tess on training.trafalgar.co.za that can give answers and responses on this topic. And really, we are here, as the managing agents, Jennifer's business as well, to provide support and guidance to improve governance, to get it right. And for some, it might be a journey. It might not be an overnight opportunity to tick all the boxes, but at least there should be a plan, there should be an intent, there should be progress to get governance improving and ultimately to be fully compliant with the expectations that Jennifer will go through this evening. I'd also just like to welcome and thank my colleagues, Karine Kutsia, Peter Menon, who are the engine room behind these webinars. So welcome and thank you both. And we'll aim to complete promptly by 6 p.m. If you wouldn't mind just putting your questions probably in the chat is easiest. There won't be an opportunity to ask them verbally, but we are more than willing to answer questions online. And if there are any repeat questions or important questions, I'll ask Jennifer to recap on those at the end. So with that introduction in mind, Jennifer, over to you. And thanks very much again, everyone, for joining us this evening.
Thank you so much, Andrew, and it's always a pleasure to be here. I think it's such an incredibly valuable service that you offer to your clients. These monthly webinars are just absolute gold for an industry where we have so much, red tape, so much legislation, so many different voices and opinions in the industry. And it's just incredible to have your training website and to be part of your offering. I really, really value that. So thank you for having me. All right, so let me just get onto my slide here. We've got our agenda. Sorry, just getting used to this. All right, so we've done our introduction. We're going to go through my webinar now. Then we'll have a Q&A where all four of us, for the 3 Trafalgars and 1 Jennifer Paddock and Associates, will help you. And then we'll go into closing. So let's get started with this topic, which is our compliance chaos.
While we wait for Jennifer, I think what we're going to see now is, a list of important topics and really how they sequence through the year in terms of, attending to them and a checklist to work through them. They're not that complicated if one is aware of them and, certainly has a sort of plan that is developed in advance. So Jennifer, have you got your notes? I can come back to you.
Yes, I'm back. Can you hear me? So thank you so much, everyone, for being here, taking the time to educate yourselves today and upskill yourselves on this important topic of community scheme compliance. So as a lawyer, I'm looking at this topic through a legal lens, what the law requires of your community scheme and its executives. And as I'm sure you can imagine, this is an enormous topic, and I won't be able to get through everything, but we will do our best to cover as much as we can for you in the time that we have together. So I want to start by saying that most community schemes don't get into trouble with compliance because people are dishonest. What tends to happen is that important compliance obligations simply get overlooked. So Peter thought that Joe was doing it. Joe thought it was the managing agent's job. That sort of thing is how our compliance lapses tend to happen in practice. So what I'm saying is that compliance chaos rarely seems to arrive suddenly or dramatically. It tends to arrive one overlooked or unknown obligation at a time. And so in today's webinar, we're going to help you move from compliance chaos to compliance confidence. And we're not going to bombard you with all the law, but we're going to help you understand a handful of compliance areas that really do matter. All right, so let's go into the next slide, what we are covering today. So we're going to look at some of the biggest compliance risks for bodies, corporate and homeowners associations. We're going to look at what scheme executives most often overlook. And then we'll move on to AGM compliance timelines. We'll move into some of the biggest financial compliance essentials. We'll look at POPI and PIA and information officer requirements. We'll then move on to CSOS annual return requirements and CSOS levies, as well as governance documentation checklists for your scheme. And then we'll look at the consequences of non-compliance. And finally, we'll finish with a 12-month calendar, compliance calendar, or how to help you build your own 12-month compliance calendar for your particular scheme. And before I dive into the substance, I want to briefly orientate you on the legal landscape, because the layering of laws in community schemes is in itself a compliance risk, because scheme executives often don't understand which laws regulate their particular scheme, let alone what those laws require from a compliance perspective. So let's move on to the legal framework now, which we'll start with towards the bottom, sectional title, bodies corporate. Now, bodies corporate need to comply with the Sectional Title Schemes Management Act, the STSMA, and its regulations, which include the prescribed management and conduct rules, as well as any additional or amended rules if they have been validly made under the STSMA, either by the developer or the body corporate. For survey and registration matters, the Sectional Titles Act also applies to sectional title schemes. Okay, then we have our homeowners associations, and with homeowners associations, we have two different types in South African law, where an HOA can be structured as a non-profit company, in which case the Companies Act applies, and we have a MOI, which is a Memorandum of Incorporation. That is the main governance document that the scheme is bound by. And underneath that MOI, you'll have subsidiary rules, for example, architectural, landscaping guidelines, that sort of thing, as well as conduct rules made under the MOI. Then we have our HOAs established as common law associations, and these are voluntary associations made under our common law, and they operate under a founding document known as Constitution. And any subsidiary rules made under that document, as well as the common law generally, particularly the common law of contract and association. So you've already got all these different laws that are particular to either HOAs or sectional title schemes, but then cutting across all of that, we have the Community Schemes Ombuds Service Act, so the CSOSA, and its regulations, which apply to every community scheme, regardless of the type. Then we have POPI, which is the Protection of Personal Information Act. We have PIA, the Promotion of Access to Information Act, and those apply to all community schemes. And then, of course, we have the Constitution of the Republic of South Africa, which underpins all of the law. Now, moving forward in this webinar, quick note on terminology, because we're dealing with compliance in community schemes generally. We're looking at bodies corporate and we're looking at homeowners associations. I'm going to use generic language. So I'm going to refer to community scheme, to scheme executive, instead of body corporate or HOA or a trustee or director, for example. Unless I'm talking about the specific type of community scheme, I'll use the more generic terms. Okay, so let's get cracking with the biggest compliance risks for community schemes. Now, I've chosen two that I think are the biggest, and that would sort of keep me up at night. And they both fall into the financial compliance risk bucket. So the first situation is a nightmare scenario, which is financial misappropriation or theft of scheme funds. And this risk area or compliance area is in fidelity insurance, okay? So as an owner, you trust your executive committee and your managing agent with your money every month. When you pay your levies, you are entrusting it to somebody else who's managing the money on behalf of the scheme. Now, if a rogue agent or scheme executive takes those funds and disappears, then your scheme can face total financial ruin. Thankfully, you are all Trafalgar clients, so this is not a risk that needs to keep you up at night because you're in very good hands. But in in the industry generally, misappropriation is a real risk. And to combat this, the law provides a safety net, but obviously it needs to be used. And that is that the managing agent must be registered with the Property Practitioners Regulatory Authority, the PPRA, and they must hold a valid Fidelity Fund certificate. Also, every community scheme needs to have fidelity insurance coverage to a mandatory minimum amount that's specified in the regulations under the Community Scheme of Service Act. And this fidelity insurance amount must be reviewed and updated every single year based on the scheme's budgets, its investments, and its reserves to ensure that if the worst does happen, if the scheme's funds are stolen, that the right amount of money is actually covered. So if your scheme doesn't have sufficient fidelity insurance or it doesn't update its fidelity cover annually, then your scheme funds are exposed. Should there be an unfortunate incident of theft, if you don't have the adequate coverage, then those protections are not in place, and your scheme faces not only a non-compliance, but also a potential complete financial collapse. So this is not a theoretical risk. It has unfortunately happened in practice over the years, less so now, but with these safeguards in place, but we have seen it happen. Okay, so in terms of a confidence checklist, you want your managing agent registered with the PPRA, you want them to have a valid Fidelity Fund certificate, your scheme needs adequate fidelity insurance coverage, and the fidelity coverage should be updated annually based on your budgets, investments, and reserves. And I'm sure that Trafalgar's got that all under control for you. Okay, then our second major sort of compliance risk in the financial sphere is poor financial management. So this is not deliberate theft, but this is a sort of slow destruction of your scheme. And it manifests in one or more of the following ways. The first is bad budgeting. So a scheme's budgets that aren't reasonably sufficient. So under the Sectional Title Schemes Management Act, in Section 3, we have this requirement that budgets need to be reasonably sufficient to cover the scheme's expenses. If the budgets aren't reasonably sufficient to meet the operational and long-term costs, then we're going to have a knock-on effect of very poor consequences, which I'll get to in a second. So bad budgeting, levy accounts, if they are allowed to fall into chronic arrears, then the scheme is going to have incredible cash flow problems. And if cash starts to run out, then scheme suppliers won't be paid. And so interest and penalties are going to get loaded onto the scheme's debts, putting the scheme further into the red. And then general common property maintenance is going to get deferred. And the great plans that the scheme has in terms of its maintenance, repair, and replacement plan are going to get pushed out. And so that means that the property itself is going to start to fall into a state of disrepair. So special levies are all of a sudden dropped on owners, residents' trust starts to decline, the building falls into visible disrepair, financial management is not rectified, and the property values plummet. These are our sort of nightmare scenarios when it comes to theft and poor financial management. So a compliance checklist in relation to financial mismanagement is making sure that your scheme has realistic budgets in place that are reasonably sufficient to cover your scheme's actual anticipated costs, and that you have robust arrears management, and that you have timeous payment of your service providers. So thankfully, as I said, with a professional management team like Trafalgar anchoring your financial governance, these specific risks are neutralized entirely in your case. All right, let's move on to what scheme executives often overlook from a compliance perspective. So let's start with physical issues. One major issue that I see all the time in practice is unauthorized alterations. This is one of the most overlooked risk areas. So in a community scheme, an owner is not allowed to make alterations to their own property, their private property, or to the common property without the community scheme or the executive committee's consent. But as I'm sure you've experienced in your own scheme, many owners often just go ahead and make unauthorized alterations anyway. When scheme executives turn a blind eye to unauthorized alterations, for example, converted garages or additional structures or changes to external finishes, they create legal and insurance complications, not to mention maintenance and repair complications that become increasingly difficult to resolve over time. One of the most common disputes that comes across my desk as a lawyer in practice in this area is maintenance disputes related to unauthorized alterations in the scheme. So when these things have not been dealt with, they have not been regularized or forced removal, then over time, who is responsible to maintain that chimney that was, put in by an owner because they wanted to put in a beautiful fireplace inside their section? Now they've gone through the common property roof and it's caused issues, and who's responsible for that? So it's comes across my desk all the time, and it's a real problem in practice. Okay, another overlooked issue is change of purpose. So for example, in a sectional title scheme where a section is designated as a garage, you'll often have these situations where a garage is converted into a home office or maybe even a bedroom. And it's that particular section is being used for a purpose other than that which it is described to be used for on the sectional plan or in terms of the building plans, etc. And there hasn't been the proper authorization in place to change that purpose. And this can affect the scheme's insurance, the zoning of the property, and potentially even the rights of neighboring owners. Another overlooked issue is informal common property use arrangements, not formalizing these. So parking bays allocated without formal leases or exclusive use areas, storage rooms lent to owners without documentation, garden areas fenced off without formalizing that arrangement. These all create enormous problems, and these arrangements need to be formalized either through properly creating exclusive use areas in the case of a sectional title scheme, or through written lease agreements in other cases. So in terms of a compliance checklist for physical issues, we are looking at regular physical compliance inspections. And when we get to our compliance calendar at the end of the webinar, I recommend that twice a year you should go around your scheme and have a look and look for any unauthorized alterations, change of use, or rule breaches. It's really good to have a physical inspection of the scheme. Then another compliance thing is to either regularize or force removal of the unauthorized alterations. As I said, something that's very often overlooked, and also regularize the unauthorized use of the common property. And then we have formalizing arrangements for all private common property use. So parking, storage, garden areas, those things that are happening informally, we want to make sure that that's all done in compliance with the law. All right, then moving on to administrative issues. One of the biggest problems when it comes to compliance is casual decision making. I'm sure you've experienced this if you are a scheme executive. Many schemes operate very casually. These days we have WhatsApp, and you have a WhatsApp group for the executive committee, and resolutions are being passed with thumbs up emojis. There's no formal written resolution in sight, but these decisions are being taken way too casually. And when it comes to meetings, schemes can be plagued by invalid notices, incorrect quorums, and improperly calculated voting thresholds. And these might seem like technical details, but they can invalidate important decisions and expose the scheme to challenge. So every resolution needs to be taken properly, and it needs to be impeccably recorded. Okay. Then another issue when it comes to admin issues is unenforceable scheme rules. So in sectional title, trustees often assume that their pre-October 2016 rules are still valid and enforceable, even though they haven't passed CSOS quality assurance or been given a Section 10 certificate. And while some of those rules may still be valid and enforceable, some of them may not be. And so it's really a good idea to do an audit of the scheme's rules and actually submit all the rules to the CSOS for quality assurance and to get that Section 10 certificate, especially in the case of your sectional title schemes. Then another issue when it comes to admin is conflicts of interest not being disclosed. It seems, I don't know if it's a South African thing, but there's always someone who's got a company that can do the job, and an executive committee members using their brother-in-law to do the painting or whatever the case is. And these conflicts of interest, whether direct or indirect, are not getting properly disclosed, and the conflicted party is not recusing themselves from the discussions or the voting around a particular issue where they actually are required to do so, not only under the STSMA, where it's specifically laid out, but also under the Companies Act for non-profit companies, and also the common law for common law association HOAs. The conflict of interest provisions are across the board in our law, and they are often overlooked. Okay, so from a compliance confidence checklist point of view, we want formal resolutions in place for all scheme decisions, either recorded in meeting minutes or formal round-robin resolutions. We want our meeting requirements met, so we want our minimum notice periods complied with, compliant meeting packs delivered within required notice periods, required quorum thresholds being met, and correct calculation of voting thresholds. And we want impeccable scheme records maintained. For sectional title schemes, ideally having a full audit, update, and CSOS quality assurance resulting in a Section 10 compliance certificate being issued, and then some training for our scheme executives around conflict of interest and their fiduciary duties. All right, let's move on to AGM compliance timelines. So the AGM is the most significant compliance event in your scheme's annual calendar, and getting the process right from preparation through to post-AGM obligations is critical. So I'm going to take you through it in these 4 phases. The first is pre-AGM preparation, which begins immediately after the financial year end for your scheme. So in sectional title schemes, the AGM must be held within 4 months of the financial year end. So each year, the scheme's financial year end triggers a mandatory AGM prep stage. In terms of HOAs, the MOI or constitution will usually require the AGM to be held in each calendar year, and there's often a requirement that there must not be more than 15 months that must lapse between AGMs. So the following must be done before you can send out your AGM notice. So this is in your phase 1 pre-AGM. You need your annual financial statements drafted and submitted to the appointed auditor or accounting officer. You want your 10-year maintenance, repair, and replacement plan reviewed and updated. Your administrative and reserve fund budgets for the new financial year prepared. Insurance replacement value schedules updated. Body corporate insurance policy documentation prepared for the AGM's consideration. There needs to be a trustee or director's annual report. You want to confirm your AGM date, time, and venue. And then you need to get all your ancillary documentation for your AGM pack collated, like your proxy form and your trustee or director nomination form. And you want to collate all of that into a proper AGM pack. Okay, then you have your phase 2, which is the notice phase. And this is once your AGM pack is ready, it needs to be sent out to all persons entitled to attend, and the minimum notice periods need to be complied with. So in sectional title, the standard notice period, if there's no special business on the agenda, meaning no special unanimous resolution to be considered at the meeting, it's 14 days if it's a standard AGM with no special business. If there is special business on the agenda, so there is a special or unanimous resolution to be considered, then your notice period moves up to a minimum of 30 days, okay? And you need to put the wording of the proposed special unanimous resolution in your notice. For HOAs, non-profit companies, if the HOA is a registered non-profit company, the statutory minimum notice period is 15 days, 15 business days, unless the MOI prescribes a longer period. For common law HOAs, the notice is governed strictly by the Constitution. And it's usually between 14 and 21 days. All right, then you move on to phase 3, which is the meeting itself. And so you have the AGM. On that day, you need to confirm that the quorum is present before opening. Without a quorum, the meeting can't validly proceed. As we know in practice, often we have the automatic adjournment to a week later, same time, same place. Once the meeting is started, we need to work through all the mandatory agenda items. And for sectional title schemes, this is regulated by PMR 176J. For HOAs, it's usually in the constitutional MOI, what specific items need to be dealt with in the agenda. Okay, so once you have gone through your AGM, you have held the meeting, then you have your post-AGM phase, which is phase 4. This is where your new board of trustees or directors need to immediately hold their first meeting, ideally straight after the AGM. And at this meeting, they will elect a chairperson from amongst their number, and they will also pass the required executive committee resolution to raise the levies based on the budgets which have been approved at the meeting. Now, we also, during this post-AGM phase, need to prepare the draft minutes of the AGM, and in sectional title, these should ideally be distributed within 7 days. And then you also want your PMR 25-1 notices sent to all owners within 14 days of the AGM. So this notifies all owners of their new levy contribution amounts, the due dates for payment, and the interest rate, what happens if they don't pay on time, etc. We also need to update the insurances where required and submit the CSOS annual return, which we'll deal with in a sec. And for non-profit company HOAs, you'll also need to update SIBSE with the directors register, the new directors to be placed on the register. All right, so that is AGMs. Let's move on to some financial compliance essentials. So the first thing that I've put here is separation of funds. So you need to ensure absolute separation of the admin and reserve funds. And the reason that I put this first is because so often in practice this doesn't happen. We need separate books of account and separate bank accounts for the admin and reserve fund. Under Prescribed Management Rule 22, a body corporate must establish and maintain a reserve fund for the future maintenance and repair of major common property capital items based on the body corporate's maintenance, repair, and replacement plan. But often in practice, we see scheme executives treating the reserve fund as a piggy bank to dip into whenever the admin fund starts to run low, or if the scheme executives don't want to upset owners with higher levies, they won't increase the reserve fund levies very much in the budgets, and then we end up with not enough money sitting in our admin or our reserve fund. And this has long-term financial consequences. The reserve fund is not a backup admin fund. It's there to cover the costs of defined, planned future maintenance and repair of major common property capital items. And even for HOAs where reserve funds aren't mandatory in terms of the law, it is very much recommended that HOAs have a dedicated reserve fund and an MR&R plan, so that the major capital communal property items in the scheme can be attended to and maintained properly over the future. Okay, then the next thing that which we've already touched on, is realistic budgeting. So as I mentioned earlier, a body corporate has a statutory duty to establish and maintain funds that are reasonably sufficient to meet its financial obligations. Realistic budgeting is key to ensure that the scheme's budgets accurately reflect its properly projected costs. And the budget should account for things like inflation, potential increases in costs, and unpaid levies. So if the scheme historically has had substantial levy arrears and circumstances have not changed, you need to budget for a levy income shortfall to ensure that you will have the money that you need to spend when you need it. So it's very much a cash flow sort of mindset as well, based on what money is actually coming in and going out. Then when it comes to raising your levies, you need to make sure that levies are properly raised and properly apportioned amongst owners. So when it comes to apportionment, in practice, we often see incorrect apportionment of contributions. In sectional title, collecting contributions on a basis other than PQ without the required Section 11(2) rule in place. And so that's something that is non-compliant and can, be challenged later. As for levies being properly raised, we need to ensure that there is a trustee or director resolution in place, formally raising the levies after the budgets have been approved at the AGM, this particularly for sectional title. And for HOAs, the wording of the executive committee's resolution raising the levies is legally significant when it comes to arrears collection. So we've got our budgets approved at the AGM by the owners usually, and then we have our executive committees taking a resolution to raise the levies, and that resolution is very important when it comes to arrears collection. We need to ensure that the required resolution is in place, authorizing the charging of interest, so that we can charge interest on any arrears. And we need to ensure that for sectional title, specifically Prescribed Management Rule 25(1) and 2 notices are sent to owners, informing them of what their levies are and the due dates and interest rate, etc. And then the final demand notices for those owners who are in arrears before those owners are handed over for formal collection. Then proactive levy collection, timely billing and collection of levies is essential. Trustees, in conjunction with managing agents, should implement written procedures for issuing levy statements, following up on arrears, and initiating legal action against persistent defaulters. And please, please don't resort to illegal collection methods like adding arrears to utility meters, deactivating access cards, setting off arrears against insurance payout in respect of a section or private property. Scheme executives expose their scheme to lawsuits with adverse cost orders when they resort to self-help tactics to get owners to pay their levies. So always follow the proper channels, be guided by your managers at Trafalgar, and don't resort to self-help because that can get your scheme into a lot of trouble. Okay, and then finally, valid fining. So if you are fining owners and occupiers for breaches in your scheme, you need to ensure that you have underlying legal authority to do so. So for sectional title schemes, this means a valid and enforceable CSOS compliant fining rule needs to be in place. For HOAs, this means that your MOI or constitution must contain a provision that authorizes the implementation of fines or penalties. All right, moving on to POPI, PIA, and Information Officer requirements, which is the next slide, please, Kareem. This topic could be a whole webinar on its own, and I actually did a webinar for Trafalgar last year on access to information and community schemes, which you can find on the training website if you're interested in more detail. But for the purposes of this webinar, every body corporate and HOA is considered a responsible party under the Protection of Personal Information Act, meaning that it collects and processes personal information, and so the scheme is legally obligated to do so lawfully, reasonably, and securely. Personal information in your scheme includes things like owner and occupant names and contact details, financial records, CCTV footage, access logs, and any correspondence that identifies an individual. Your POPI obligations include, as a scheme, appointing an information officer. So in practice, this is typically the chairperson of the trustees or the directors or the managing agent. Registering the information officer with the information regulator. This is mandatory and it's done online at the information regulator's website. Implementing a PIA manual, more on this shortly, and implementing appropriate security safeguards to protect personal information. Only retaining personal information for as long as is necessary for its original purpose, and not disclosing personal information to third parties without a lawful basis. So the information officer registration requirement, the information officer, as I mentioned, must be registered with the information regulator. It's not optional, and failure to register an information officer is a contravention. Then we have PIA, and this is where the Promotion of Access to Information Act requires every private body, which includes community schemes, to compile a PIA manual, and the information regulator has confirmed the community schemes must have PIA manuals. And so the PIA manual describes the categories of records held, how to submit a request for access, and the fees applicable. And then a few PIA points. A PIA request for access to information must be responded to within 30 days. And you may refuse access to the information on specified grounds, including where disclosure would be an unreasonable invasion of a third party's privacy. The PIA manual must be made available to members and the public on request, and an updated PIA manual must be submitted to the information regulator. Okay, let's move on to CSOS annual returns and levies, which is the next slide. So in terms of annual returns to the CSOS, the Community Scheme Ombuds Service Act and its regulations requires all community schemes to file their annual returns to CSOS within 4 months after the end of the community scheme's financial year. The point of these annual returns is for the CSOS to conduct quality control checks on the scheme's documentation and to assess whether the scheme is compliant with the Community Scheme Ombuds Service Act, the Sectional Title Schemes Management Act in the case of sectional title schemes, and any other applicable legislation. The submission of annual returns must be accompanied by certain documents, which are on the screen there. Firstly, you need your completed prescribed form, which is Form CS2, and that needs to be signed by the developer or 2 scheme executives or 1 scheme executive and the managing agent. And then you must also submit annual financial statements. You need to submit draft AGM minutes and the approved levy schedule and resolutions. If the community scheme is found by the CSOS to be compliant, then the Chief Ombud will issue a Section 59B1 compliance certificate, and that compliance certificate is valid for a period of 3 years. Non-compliant schemes will be notified and issued with a non-compliant certificate and will be required to comply within a specified period. Failure to comply results in the allocation of an account executive or an account officer to enforce compliance, and the officer's report then determines whether or not a fine will be imposed on the community scheme. Okay, then moving on to CSOS levies. Under the regulations to the CSOSA, every community scheme must collect a CSOS levy from each owner on a monthly basis and then pay these levies over to the CSOS on a quarterly basis. Non-payment of levies on the due date will attract interest calculated at a rate prescribed under the National Credit Act and constitutes an offence. Okay, let's move on to governance documentation. We've got a couple of checklists here. One is sectional title specific documentation, one is HOA specific documentation, and then on the next slide, I've got an all community schemes checklist, which applies to any type of community scheme regardless of its type. So for sectional title schemes, we have management and conduct rules, as well as any CSOS compliance certificates in relation to the rules, like a Section 10 certificate. We have sectional plans and any future development plans or reservation documents under Section 25 of the Sectional Titles Act. We've got a record of exclusive use areas, if applicable, that may be in the form of the EUAs being shown on the sectional plan itself or in a layout plan attached to the scheme rules. And then we also have our maintenance, repair, and replacement plan as required by PMR 22. So that's sectional title specific. Then HOA specific, we have your approved MOI constitution, as well as any subsidiary rules, guidelines, etc. Title deed conditions, registered surveyor general plans, and municipal approvals like the record of decision. And then for non-profit company HOAs, we have all the SIPC documents. So your company registration certificate, your registered, your members and directors registers, and your returns to SIPC, etc. Okay, then moving on to the next slide, we have the governance documentation for all schemes. And these include your CSOS registration certificate and CSOS annual return submissions, approved building plans or schematic diagrams, details of servitudes and town planning and zoning conditions, annual financial statements and tax returns, insurance policies and schedules, a bank account confirmation letters, a contracts register, and I've just put their track expiries because many schemes have a contracts register, but they don't track the expiry dates, and so the contracts then roll over onto a month-by-month contract or renew without anybody really knowing about it. So it's good to just keep track of that. Then we've got our PIA manual and POPI documentation, for example, proof of information officer appointment, any court or adjudication orders related to the scheme, all your meeting documentation, so your meeting packs, attendance register, minutes of meetings, you need to keep all of that, as well as written resolutions. And then lists of executive committee members, owners, tenants, bondholders, etc. And then compliance certificates, so electrical, solar, fire, lift, lighting, all of those. And then finally, records of scheme-related correspondence or communication. Okay, let's move on to consequences of non-compliance. So what actually happens when schemes get compliance wrong? And I want to just say here that compliance is not an academic exercise. There are real consequences, a few of which I'll set out for you here. From a financial perspective, if a scheme doesn't comply with the realistic budgeting requirement, then crippling special levies are often the result. And if a scheme is underinsured, it may face enormous financial exposure if there is a major claim or major damage to the scheme. From a governance or administrative perspective, a scheme that can't prove proper authority may struggle to enforce its own decisions or rules. And a scheme with poor governance often experiences increased conflict, increased disputes, and declining owner confidence. From a legal and regulatory perspective, the scheme may face adverse CSOS or court orders, fines from the information regulator for POPI breaches, CSOS penalties due to non-compliance, assessments after annual return submission, and for non-profit company HOAs, company deregistration is the risk of non-compliance. And that isn't theoretical. I actually have been dealing with a client over the last few weeks who is a non-profit company HOA that has been deregistered by CIPC because of lack of compliance, and they're trying to get the company reinstated. So that's just something that came across my desk in the last few weeks. From a personal risk perspective, trustees of bodies, corporate and trustees or directors of HOAs owe fiduciary duties to the community scheme and its members. Where a scheme executive acts outside their mandate, breaches a fiduciary duty, or causes loss, they can face personal civil liability. And let's face it, when a community scheme is experiencing widespread non-compliance, owners and residents aren't happy, the estate falls into a state of disrepair, and property values for all involved tend to decline. Okay, and finally, we'll go on to our last slide, which is creating a yearly compliance calendar. So it's really helpful to create your own 12-month compliance calendar to keep your scheme on track based on your particular scheme. And I haven't named the months here. When I said timeline and phases down the left-hand side, I've just put month 1, month 2, etc. Because different schemes have different financial year ends, and some tasks, are linked to the end of the financial year. So we've just put, month 1 post financial year end, month 2, etc. So there are some compliance tasks which you're going to complete every month, right? Like related to your levy collections. So you're going to have a monthly levy statement being sent out. Then you're going to have first reminder notices for non-payment, normally on the 7th of the month, followed by a formal demand, maybe on the 21st of the month, depends on how this works in Trafalgar, your particular scheme. And then a date towards the end of the month, or end of the second month, or whatever it is, where the debt is then handed over. So you'll have these sort of monthly tasks, and one of those should also be formal authorization of payments out of the admin and reserve fund, so that all payments are properly authorized. Okay, in month 1, post financial year end, it's all about your AGM prep. So in this month, you're going to be preparing your draft annual financial statements. You're going to be reviewing the maintenance, repair, and replacement plan, and then preparing the proposed admin and reserve fund budgets, reviewing insurances and obtaining any new replacement valuation schedules if due, and preparing the trustees or directors' annual report. So it's basically getting all the documentation in order that you're going to need to be considering at the AGM. And this is also the month where you would be considering your interim levy increase, if needed. So in that case, at least in sectional title schemes, the trustees would be passing the written trustee resolution authorizing the increase of up to 10% and sending out the formal notice of interim levy increase to all the owners. Then in month 2, and this is all, this is not the legislation says you have to do it like this. This is just an idea of how this might look in your scheme. And, you may have a different sort of cadence to all of this. Months 2 and 3 would potentially be your AGM push. So you're going to set the date and time for your AGM, secure a venue, prepare notice and agenda of the AGM, create and collate all the accompanying documentation, send your comprehensive AGM pack to all persons entitled to attend. And then you're actually going to hold your AGM, hold the first trustees meeting post AGM, compile and distribute your draft AGM minutes and trustee or directors meeting minutes. And for nonprofit company HOAs, you're going to update your CIPC directors register, update your fidelity insurance cover and other insurances if required, update your information officer details if required. And then in month 4, we have, you've got your AGM completed within the 4-month deadline, and now you need to submit your CSOS and your return. Month 5, I've put here, review all staff contracts and check expiry dates. Month 6 and 12, I've put physical inspection of the scheme. So go and identify all those unauthorized alterations, rule breaches, anything that's out of, that's non-compliant. And it can also be a good time to confirm the lists of section owners, tenants, bondholders, ensure that all those details are up to date. And then in month 7 to 11, there can be further reviews. So each month can be the review of something different. So, in month 7, for example, start by reviewing the minute and resolution book and make sure that that's up to date. Month 8, maybe review your PIA and PUPI compliance. In month 9, review your scheme plans and building plans and schematic diagrams and all of that. And then in month 10, maybe look at your scheme rules. And in month 11, look at all your compliance certificates. Month 12, again, you would be doing your physical inspection of the scheme and again, looking at your lists of owners, tenants, bondholders, etc., to make sure those are all up to date. And don't forget to also slot in your quarterly CSOS levy payments into that calendar as well. So those are some ideas. I hope that that's helpful. I know I've thrown a lot of information at you over the last sort of 30 minutes or so. And I'm sure that you've got lots of questions. So I will leave it there. Thank you for your time this evening. And let's open the floor for Q&A.
Excellent. Well, thanks very much indeed, Jennifer. And that's super, super interesting and informative. And just for everyone, you will get the slides and a link, and certainly that will be a good reference document to go back to. Jennifer, Peter and Karine will chip in if they've spotted any questions, but just to start the ball rolling, one of the challenges of the industry is the transient nature of trustees and directors who are elected. They serve their time. It can become quite time consuming in terms of exercising those fiduciary duties. And then, they would move on and hand the baton over to somebody else. So, there's not long-term surveillance or coverage of these responsibilities, which does make it complicated, to get things up to date and then to keep them up to date. And also not many people have experience in the industry with these responsibilities. So it can be very intimidating to learn all of this responsibility and legislative context and, to action it. And obviously to try and do this part-time outside of a full-time job and after hours, etc. So that is the magnitude of the challenge. So, I don't know if you want to just comment on that, but, it's worth saying there are professional trustees which do this for a living, which can be elected to perform a role that would help with this. There are more and more buildings where nobody wants to be a trustee or director because they see risk, they don't have the time, there's not a lot of appetite, and that's where executive managing agents come in terms of sectional title schemes to take on this responsibility, and typically by somebody that has the experience, that has the know-how, and who has the time as part of a full-time job to do it. So just any comments, Jennifer, on how to navigate that landscape?
Yeah, absolutely, Andrew. It's really, really interesting. It's a difficult one because you have volunteer trustees who are generally not paid, but are expected to comply with fairly high standards of fiduciary duty and to have actually quite a lot of knowledge and education around a topic which most people don't know, in terms of the legislation and how these decisions need to be made, what compliance boxes need to be ticked. And so it's completely understandable that there's a lot of apathy on the part of, owners to put their hands up to take on these positions. And as you say, it is very transient. Somebody will come on for a year and be enthusiastic, and then they'll realize that they don't like having to put in, it's almost having a second job, but not getting paid for it. So I think that the idea of professional trustees is really good. And that would potentially provide more consistency and longevity in terms of having, the same person there, even if it's just one professional trustee with the other volunteer trustees changing around them each year. There's still at least that level of consistency. And because it's a professional trustee and they're getting paid, you can demand sort of more from them, as with an executive managing agent. And I think that these are two concepts which are really, they're starting to gain some traction in our jurisdiction, but I think they're going to gain more and more traction. If you look at, a jurisdiction like Australia, the managing agents there basically act like executive managing agents. There's a lot of delegation from the boards of trustee where they can ask the managing agent to make decisions on behalf of the trustees. And if that's in the management contract, the managing agent basically runs the scheme on behalf of the trustees. And we don't have a lot of that here unless it's an executive managing agent appointment, which is still gaining traction. So I do think that we've seen it overseas. It works. It would be great to have more sort of executive management here, take the pressure off the volunteer owners, and professionalize it, because it is a lot to take on as a volunteer role. It's a real challenge.
Yeah, no, I agree. And I mean, I think, as you mentioned, Jennifer, there's plenty of documents that are underpinning the, the governance and all of the milestones that you spoke about. It makes sense that those are on a drive somewhere. For example, we have a web app, and, those documents are archived there. They are accessible online from there, and, that can be found and reviewed as and when a relevant decision or a relevant query sort of crops up. But, Google Drives, there are many online resources now. It does make sense that all of these documents are online, are organized, are well labeled, and they are accessible to all trustees and directors, to use. And, just going back to that point about, the transient role of trustees and directors, I think, it is the responsibility of trustees and directors to get governance right and to make sure they're ticking those boxes. But it is a process, it is a journey, and I think it would be, beholden on trustees and directors to leave the community scheme better off than where they found it, to check on the baseline, to identify gaps, to work with their managing agent and portfolio manager to progressively address those gaps. And so, month by month, year by year, the standards improve, the governance raises, and when they exit and hand over, there's a better baseline than they found, and, so the continuity should continue. I think you did mention that, getting a lot of those source documents right does make dealing with disputes and complications that much easier, because there's a sound legal basis and a sound document trail to go back to underpin the dispute and obviously get a favorable decision, and, just to fast track or streamline the way those are dealt with. So any observations on that, Jennifer?
Yes, I mean, impeccable record keeping is the strongest way to protect your community scheme, particularly your body corporate or your HOA, from disputes. Because if you can show that you have passed, resolutions correctly, that your meeting technicalities were all on point, then it's very difficult for anybody challenging the decisions of the executive committee or the community scheme itself to actually prove that, that the decision is unenforceable or invalid or void. And so, impeccable record keeping is the upper hand. And so it's very, very important, and something that should be given a lot of attention in community scheme management.
And I think you mentioned it as well, Jennifer, that, just dealing with things quickly and decisively just avoids a whole lot of complication down the line, because these matters tend to escalate and compound and just become more complex over time. So, following the program you mentioned, or dealing with things quickly, all important. And, I find as well that, where there is a dispute, related to any of these issues, let's take conduct rules as an example, it's so important to, number one, make sure the rules are correct, enforceable, and approved, but then take action consistently. And that manages expectations of the members and the residents, very quickly. People know what to expect. They know what to, how to sort of, conduct themselves. And it just leads to a more harmonious, pleasant, and positive living environment, which actually is the bottom line, isn't it? Just a functional, comfortable, well-serviced and well-supported sort of community scheme, which actually, grows property values, which is really the outcome of getting this right, isn't it?
Absolutely. And I think you've touched on something really important there, which is, being consistent with the enforcement of scheme rules, because there are many schemes which engage in selective enforcement, and that creates such a problem amongst residents and owners, because why did you enforce the rule with my neighbor but not, why are you enforcing it against me but not my neighbor? It's not fair. All of that sort of thing. So I do think that it's almost like, dealing with a child. It's like, you need to be consistent, you need to be fair. Everybody needs to know what to expect. And that just, as you say, creates a harmonious environment for everybody involved.
Yeah. And, just another important tip is that, there should be, management information shared to the trustees and directors on a monthly basis, which, really covers the full financial status, bank balances, levy arrears, actions on levy arrears, maintenance costs, etc. So, it is important that, the trustees and directors set time aside to review that monthly management information, because that really is the dashboard,
Yes.
on what's happening, how it's progressing, what the trends indicate, and to take action at an early stage, or to monitor that, progress is being achieved. And, it does become difficult if those management reports are, number one, not available, but number two, not reviewed, because then, the community scheme is really flying blind, and there's not sort of awareness of how these things go. And, really, if there's cash flow and, a surplus to budget, buildings tend to run well, because there's funding to pay the costs, keep services going, to keep maintenance up to date. And that does tend to support a happier and, more stable community scheme. And when that goes wrong, it can become very complicated very quickly, which is a concern.
Yes,
Any,
well said.
any closing comments, Jennifer, just in terms of this topic?
I don't think so. I think, every community scheme needs to have its own compliance sort of calendar, but there are threads that run through every type of scheme, regardless of whether it's a body corporate or a sectional title scheme. And so, yeah, the more you can educate yourself about what needs to be done, the less intimidating it is, and to put these structures in place, to know what you're going to do on a monthly basis, what you're going to do on a quarterly basis. I think it just helps and really takes the stress out of all of it. So thank you for thank you for the opportunity to share some light on this very large topic. And I'm sure there's a lot more to it that you are training your schemes on as you go with your management.
Excellent. Well, thank you so much, Jennifer, for joining us and for a very informative presentation. Our contact details are on the screen, so, and offered to anyone, if you've got questions that weren't answered or that crop up, by all means make contact. We do try and get back, and respond with advice, with recommendations, etc. Also, it can seem overwhelming, the legal landscape, but, in the age of ChatGPT and Gemini and AI tools, it's very easy to put in a question, find the legal reference, get a detailed response. Our own training website, it has all of the legislation loaded. It has all of these webinars, etc. So any practical question which arises related to governance, related to the legislation, you will get a sensible response. There will be the references to the correct legal clause and underlining legislation. And so, that's the way to learn, is to use the tools available, tackle practical issues as they come up in that way, and experience builds, and, lean on people that do this for a living, your portfolio manager, your managing agent, the likes of Jennifer. That's what we do. We do it full time, and, we try and make it manageable, for trustees and directors that do this part-time, after hours, with no remuneration at all. So thank you very much, everyone, for joining us. We appreciate you following these webinar series. And Jennifer, thanks once again for joining us tonight. Have a good evening, everyone. Okay.